Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming attorney Belma Burkic from our Houston, Texas office. Hi there, Belma, and welcome.
Hi, Arianna. Thank you. It's nice to be here.
Thank you so much for being here with us. So, for today's topic, we will be discussing PERM essential tips and considerations for job descriptions. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So, if you have any questions, please email us anytime at info@chuk.com so we can help you out. Let's get right into it, Belma. Can you tell us what is the employment-based green card process?
Absolutely. The idea behind the employment-based green card process is that you, as the employer, have an employee who you want to keep permanently. And the only way to really allow them to remain in the United States once their work visa expires is to have them go through the green card process. So when employers want to sponsor employees for a green card, we refer to that as the employment-based green card process. Now, there are several routes that you can take when you are pursuing an employment-based green card process, but for the purposes of today, I'd like to focus on the PERM-based green card process. And so that is a three-step process. It's a multi-year, multi-step process, and it requires active engagement from the hiring manager or the HR manager, as well as recruiters in the company. And so the three steps that are involved in a PERM-based green card process are the PERM application, which is filed with the Department of Labor. The second is the I-140 petition, which is filed with the United States Citizenship and Immigration Service. And the third is the adjustment of status application, which is also filed with the United States Citizenship and Immigration Service. So the way it works is the employer initiates a PERM-based process where it typically takes around 2 years to complete, unless you're doing batch recruitment. So you're talking about a 9 to 12 month pre-filing step, and then 12 to 15 month post-filing processing time. And unfortunately, there's really no method to expedite the PERM process. And when an employer files a PERM application to the Department of Labor, what they're saying is that Department of Labor, we looked for a US worker in the labor force, and we were not able to identify one who meets the minimum requirements for the role. So we are sponsoring our current employee for this role. It doesn't necessarily have to be a current employee, it could be for a prospective role, a prospective employee, but we're sponsoring this foreign worker for this particular role because we are unable to find minimally qualified US workers. And then once the Department of Labor reviews the employer's application and approves it, then you move to that step two I-140 process, which is about a 6 to 8 month processing time if you file regular processing, or you can file via premium processing for expedited results. Now, the I-140 is essentially the employer's petition to a different government agency, right? Not the DOL, but the United States Citizenship and Immigration Service, letting them know that you wish to employ the individual in the description or for the role described in the PERM application. And then the adjustment of status is the employee's individual application to the government asking to adjust their status from that of a temporary visa holder. So for example, someone here on an H-1B or an L-1 visa to that of a permanent resident or green card holder. Now, the timing for the adjustment of status is governed by the Department of State. Every month, the Department of State issues what's known as a monthly visa bulletin, and that tells us when an employee becomes eligible to file for the adjustment of status. And depending on the employee's green card visa number, that could be immediately upon PERM approval, you can file the adjustment of status with the I-140, or it the employee may have to wait 4, 5, 10, 12 years to file that final step of the green card process. So it is really a multi-year, multi-step process. And for individuals who were born in certain countries, for example, individuals born in India have to wait 10 or 12 years to even be able to file that final step.
Wow, I appreciate you walking us through that three-step process. I know it's only three steps, but it does sound pretty lengthy and complex there, but I appreciate you sharing all of that with us. I'm interested in a little bit more information about the PERM process. Can you go into that a little bit for us?
Sure, absolutely. So the PERM process kicks off with the drafting of the job description, and this job description carries through until the green card is issued. So when you're getting ready to start the PERM process, the first question is, are you sponsoring the employee for a green card for the position that they currently hold? Or are you sponsoring them for a future position that they will hold at the company at the time that the green card is issued? So typically what we see is most employers sponsor individuals for the current position that they hold. And if that's the route that you want to take, then you have to make sure that the job duties accurately capture the role, but are not overly detailed, so to require restarting the green card process each time there is a slight job change or a promotion to the role. If you are looking for a future looking role, then you have to make sure that the job description emphasizes the evolving nature of the position, that you're highlighting the skills and qualifications that anticipate industry trends and company needs. So a future role requires essentially, looking into the future and really trying to understand what that role will entail and what the minimum requirements for that role will be. But once you've nailed down the job description, which I really believe is the most important part of the process because it sets up the rest of the entire process, the next step is to verify that the employee meets the minimum requirements for the role. So, what that means is when you are writing a PERM job description, there's several elements that you're including, and we'll discuss those in greater detail. But one of those things is or one set of those things that you're including are things like minimum education, experience, and special skills requirements. So if you say that the minimum education requirement for the position is a bachelor's degree in computer science, and that the minimum experience requirement is 3 years of experience, and that you need experience in Java and C++, then you have to make sure that the employee who you're sponsoring for this particular green card role has a bachelor's degree, that they gained 3 years of experience prior to assuming their current role, and that they have experience with the requisite special skills that you're requiring. So once you've dropped the firm job description, then you have to verify that the employee gained those skills. And then once that occurs, the next step is to submit what's known as a prevailing wage request to the Department of Labor. This is basically where you're telling the Department of Labor, here are the job duties, here are the minimum requirements. Tell me what the minimum salary for this particular role would be in this location. And then you have to make sure that your salary that you're offering to the employee either meets or exceeds the prevailing wage determination that the Department of Labor comes back with. And you don't have to make sure that the employee meets or exceeds the prevailing wage determination salary at the time that you file the PERM. You just have to make sure that they meet that salary at the time of green card approval. So for example, the prevailing wage comes back at 150, but the employee is currently making 140. You can still proceed with using that wage as long as at the time that the green card is issued, your employee is receiving a base annual salary of 150,000. And then once the issue with the prevailing wage determination is that it takes about 6 months for the Department of Labor to issue it. So from managing your employees' expectations, it can be difficult because they get really happy that their employer is sponsoring them for a green card and the process kicks off and everything seems to be moving, and then 3 months passes and they don't have an update. Well, it's because we don't have an update. It's pending with the Department of Labor. But once we get it back, the idea is that you're ready to proceed to recruitment, assuming that the wage came back favorable and that the Department of Labor properly classified the position. The recruitment process typically takes 75 to 90 days to complete. So when we say recruitment, what we're talking about is you as the employer, and with the help of your legal counsel, can work together to complete the recruitment process in the sense that legal counsel can help you with the posting of the advertisements. So what that means is you have to post advertisements as if the position was any open role at your firm. And the choice of advertisements that you use should closely mimic the actual real life recruitment process that you follow at your firm. And they also have to meet certain mandatory regulatory requirements as well. And the idea is that the recruiters at your company or the hiring manager will review the resumes that come in during the recruitment period to see whether those individuals that applied for the role meet the minimum requirements for the position, or if they can acquire the necessary skills to perform the position within a reasonable period of on-the-job training. So, how do you define reasonable period of on-the-job training? Is that 6 months, 3 months, a year? It really comes down to the role. If it's a really complex role, then you may require more time training an individual. So reasonable is left to the employer to decide. But if at the end of the recruitment campaign, the hiring manager and the recruiters do not identify a minimally qualified US worker, then you can proceed to the next step of the PERM process. If, however, during the recruitment period, the recruiters do identify a minimally qualified US worker, then you're actually prohibited from moving forward and filing the PERM application, because remember, the idea of sponsoring someone for an employment-based green card is because there are new US workers available to fill the role. If now you've identified a US worker who can fill the role, well, then you can't proceed to filing the green card application. You can restart the process for a new role. There's other things that you can do that you can discuss with legal counsel. Just real quick sidetrack there, US worker is defined as someone who's a US citizen or green card holder, or a refugee. So if someone applies for the role and they're on an H-1B and they meet all the requirements, well, it doesn't matter. They're disqualified because they're not considered to be a US worker. Now we're almost at the tail end of the process. I know it's a lot, so just bear with me. Before you can actually file the 9089, right? So you've created the job description, you verified the employee's experience, you've received the prevailing wage, you've gone through recruitment, and now you're getting ready to file the 9089. There's one final analysis that you have to do. You have to confirm that there have been no layoffs in the same or similar position within that geographic area in the last 6 months. So what that means is, for example, if there have been layoffs in like a legal department, and this is a role for an investment banker in the investment banking department, that is not considered a layoff, because those are two very distinct roles. If there's been a layoff for that same role in the Indiana office, but this role is in the Florida office, the layoff in the Indiana office would not impact the role in the Florida office, because again, it has to be a same or similar role within the geographic metropolitan statistical area, and it has to have happened within the last 6 months. So if the layoff occurred within the last 9 months, you're still okay to file, right? As long as it's outside that 6-month time frame. So assuming there have been no layoffs, you proceed to the filing of the 9089. And the date that you file the 9089 is the priority date. That is the employee's priority date. That is their place in the green card queue. The Department of Labor will then review that 9089 or that PERM that you filed with anywhere within, I would say currently 14 to 15 months. Department of Labor processing times do change. We've seen them review these cases in as little as 9 months, and they've taken as long as 16, 17 months. It really depends on the volume of PERM applications that are pending with the Department of Labor, as well as their capability and their resources and ability to review these cases. The best case scenario would obviously be for the PERM to be approved. But there could also be some pushback from the Department of Labor in the form of an audit. And if your case is audited, it will delay the processing time by probably 6 to 8 months. Again, subject to the volume and availability of DOL officers to actually review the audit response once it's submitted. And so we can talk about some of potential audit triggers later on in the during this presentation. But the idea is that this process is a very long process, and so before you're started, make sure that you have the involvement and the attention of the hiring manager, the recruiting team, and that everyone stays on track so that the process is completed as quickly as possible from the portions that we can control. I think that's the first takeaway. And then the second takeaway is that the job description is the most important portion, because as you can see, it covers the entire process and becomes really, really important during the recruitment campaign.
Absolutely. We're definitely looking at a complex process here. And if you are watching this and have any questions about this process, feel free to reach out to us. We'd love to help you out with this. So Belma, you mentioned the importance of the job description and the accuracy of that. So who exactly should be the one that drafts the job description?
So it should be drafted by the employee's direct hiring manager or someone who is familiar with the job duties of that particular role and the standard hiring requirements for entry into that role. It should not be completed by the employee. The employee should have very limited involvement during the PERM process. Their involvement should essentially be limited to verifying that they meet the minimum education, experience, and skills requirements.
Got it. So what does the job description, what should that consist of?
So, at a high level, really what we're looking at are the job duties and then the education, experience, and special skills requirements. But there are some other portions that are critical as well. So I mentioned, when you start this process off, you have to determine, are you sponsoring the employee for a current position or a future position? So the first thing that the hiring manager has to decide is, what's the job title, right? And then the next thing that we have to look at is, what's the job location, right? What is the work location of that position? Is there remote or telecommuting aspect to the role? And if telecommuting, for example, is permitted, we have to make sure that we're specifying how many days a week is it permitted for, and really looking at, will this arrangement persist until the green card is approved, right? So if you're sponsoring an employee with a country of birth in India, the idea is, does your firm seem to be moving back to the office policy, or has your firm fully embraced the idea of telecommuting or 100% remote work, so it will persist 10 years from now? So it's a difficult question. It's a very forward-looking question, but it is a key consideration in the process. And then the other thing that you have to consider as a manager is travel required for the role? And if so, what is the frequency, and where is the employee traveling? And why is travel required? We need to include an explanation for the need of the travel. Is it, to meet with clients? The other, consideration is, if the job is located in a pay transparency state, or state with very specific pay transparency laws that require you to list the rate of pay, or even benefits language, you have to make sure that that language is included in the job description. And then going back to, what I first mentioned about job duties, you want to make sure that your job duties accurately capture the day-to-day tasks involved. But the idea with the job duties is essentially to put anyone on notice what the role entails. And if there is an element of supervision to the job duties section, you do want to include it as well. So if the individual is responsible for the supervision of two analysts, that should be included in the job description. Um, the education requirements, what that means is, are you looking to hire someone who at a minimum must have a bachelor's degree in a specific field? Well, if so, then you have to list it. Or is this role one that's so complex and technical that it can only be performed by someone with a PhD? So you want to be very specific about what your baseline minimum requirement is. When we're talking about experience, what we're talking about is how many years of experience does someone need to have to enter the role? So, is it sufficient to have 2 years of experience in the software development industry to become a software development analyst too? Or will you only hire someone for the software development analyst role if they have 5 years of experience, right? These are the kinds of questions that the manager or whoever is preparing the job description needs to ask. And then with regards to the special skills requirements, the idea is what are the essential skills that someone needs for the role such that you wouldn't hire an applicant into the position without these skills. So, for example, in the software development role, is Java absolutely required for the role? Or would you hire someone if they have any programming experience language? So, it really requires a deep sort of understanding of the role and, what managers are looking for when you're preparing the job description.
Wow, yeah, that's quite a bit of detail that you need to go into for that. So I appreciate you walking us through all of that and what's needed in there. So is there anything in particular that managers should be aware of when they're preparing the job description?
Yeah, so I kind of want to walk them through some do's and don'ts, if you will. So, what are some of the do's? Well, you want to list requirements that represent the employer's minimum requirements. Again, what is the baseline minimum needed for entry into the role? And those requirements should be essential to perform the role in a reasonable manner, right? So, if you are hiring for an investment banker and you're requiring coding experience, is that really essential to perform the role in a reasonable manner? And then with regards to the special skills, you have to make sure that they bear a reasonable relation to the role, right? So again, you're not going to require skills that are, traditionally not necessary for the role unless you can explain how there is a reasonable relationship to those roles, to those skills for that particular role. So, again, the idea is also what you do want to do because you want to be as clear as possible when you're drafting the job description so that when the recruiters or the hiring team is reviewing applicant resumes, they know exactly what the minimum requirements for the role are. So, what that means is paying special attention to the language that you're using when you are listing the experience and special skills requirements. So, for example, going back to the software developer, do you need experience with a specific programming language? Or will you accept experience with any programming language? And if it's a specific programming language, is Java acceptable? Is that the only acceptable programming language because that's the only language your team uses? Or is Python an acceptable language? Or does someone need to have experience with both Java and Python for consideration into the role, right? Because that's very different. And or an or changes the requirements. Um, so definitely biggest do is be very specific and thoughtful in terms of listing what those experience requirements are. Additionally, with the special skills, I recommend quantifying them to the extent possible. So do quantify them, say 2 years of experience with Java, 2 years of experience with C++, etc. But quantifying them allows you to be very definitive in what the requirements are. So what are some don'ts? So I said quantify them and be specific, but the first don't is don't tailor it to your employee's experience. So don't take a look at the employee's resume and then say, these are the skills. No, this process should be completely irrespective of the employee's background. When you're crafting the job description, what your only consideration is looking at that particular role and what the minimum education, experience, and skills requirements for that particular role are. And then once you've defined that, then you take a look at the employee's requirement, at the employee's background and experience, and ensure that he or she meets or met those minimum education or experience requirements before they assume the current position. So that's the first don't. The second don't is don't list preferred skills. The skills must be mandatory or required for the position. If having experience with Spring is a nice to have or a preference, it should not appear on a PERM job description. Also, don't use fluffy or subjective or vague language. These skills have to be objective and measurable because how else do you compare them against the applicant resumes that you've received for the role? So a lot of times I get, job descriptions back from managers that say, oh, this requires someone with good communication skills or a team player, which typically in real open world recruitment, these are common skills that are listed on job descriptions because they're very important. But in the world of PERM, which is very different to open role recruitment, we have to be very specific. So typically what I tell managers, instead of saying good communication skills, maybe what you want to say is experience providing project updates to senior leadership, or experience working on a team to build software development would be indicative of someone who has good communication skills in the first example, or someone who's a team player because they have experience working on a team. That is a measurable way to sort of get around some of that standard, fluffy or subjective language that we see in open world recruitment. A big no is do not list any special skills that are proprietary to your organization. So if you have a proprietary system, that cannot be listed as a requirement because it's unfair to require outside applicants to have experience with your internal system.
Wow, thank you. Oh, sorry. Do you still have another don't?
Well,
Go
not
ahead,
a don't, but I was just going to add,
please.
again, as I mentioned before, don't look at, again, I find most managers looking at the employee experience and then building out the job description from there. That's a backwards approach. Start off with looking at the role, and then we will work with the employee to see whether or not they have those minimum education, experience, and special skills. We'll have the employee complete an employee verification chart. We'll have the employee reach out to former employers for employment verification letters. So, again, the employee's experience and background is very important, but it's not what's integral when you're trying to start off and drafting that initial job description for the PERM process.
I love the way you listed the do's and the don'ts. That was really easy to follow. So thank you for covering it that way for us. Are there any other considerations that managers should be aware of?
So, despite the process being very long, it is very unforgivable. And so, one of the things that managers should be aware of is that any changes to the job while the employee is undergoing the employment-based green card process could have a negative impact and could require the employer to restart the green card process again. So if before you even start the green card process, ask yourself, how long is this employee going to remain in this specific position, in this location, completing these specific sets of job duties. And then, if you do foresee the possibility of changes, like changes in work location, changes in responsibilities, job titles, or consideration for a promotion, reach out to your legal counsel and make them aware of what changes you're considering, and then have them do an analysis for you to apprise you of what the impact would be to the green card process if such a change was to take place. For example, a promotion in and of itself doesn't necessarily require us to restart the process from scratch. It depends on where we are in the process and whether that promotion, involves a considerable change in job duties, et cetera. So it's a very fact specific and legal analysis, and you should work closely with counsel to determine the impact, if any.
Absolutely, great advice there. Can you describe how changes to the job description could impact the green card application?
At a particular stage, yeah, absolutely. So if you're at the pre-filing perm stage, right, we just finalized the job description and submitted the prevailing wage request, and now there's a change to the role, we should probably restart that perm. Let's handle that early on and update accordingly. If you're at a stage where the perm has already been filed and pending, or the perm has been approved, but we haven't filed that step 2 application, that I-140 yet, then what's the impact? So, I mean, it really depends on how impactful the change is to the nature of employment and whether or not there's still an intent to employ the beneficiary in the role described in the perm application. So, what that means, for example, is, let's say the employee is currently working out of New York in a role, and you want to continue to employ that employee in the role in New York, but you want to send them on a short-term assignment to Salt Lake City. Well, that's not going to impact it, because you're telling me at the time of green card approval, the role in New York is going to be available, and this is just a short-term assignment. Then we can absolutely proceed with the green card um, process without having to restart it. For another example is, a change within the same MSA. So the employee is now working in one office in LA, and they're going to be moving to a different office within the same metropolitan statistical area. That likely will also be a permissible change and will not require us to restart the green card process. Whereas, you started the process for the employee in Tampa, Florida, and now you want to relocate them to Salt Lake City. Well, that's a location change outside of the metropolitan statistical area, and it will require us to restart the green card process from scratch. Why does it matter? Why do we care that we have to restart from scratch? Well, cost aside, because the green card process is very expensive, especially since you have to advertise for the role. An employee's work visa, comes with a limited amount of time. So you only have a very narrow window sometimes to file a green card for someone in order for them to remain in the United States and not face a gap in their work authorization. And so that's why, changes during the pendency of a green card process, or in particular during the PERM phase, can have a huge impact, not just on the process itself, but on your employee's ability to continue rendering uninterrupted services for you in the United States.
Wow, thank you for going into that for us. Are there any strategies to expedite the perm process?
So there's very little. Like, it's not as if there is a way to ask the Department of Labor to expedite any of the steps. But there are some procedural things that you can work with legal counsel to do to help, with the processing time. So sometimes you can run recruitment in parallel to the prevailing wage request pending. So if you'll remember, right, the prevailing wage request is currently taking the Department of Labor 6 months to process. And so if you want to have recruitment run during the 6 month period, you can, but you have to be pretty cognizant of a number of things. The first is that recruitment is only valid for 6 months. So you don't want to start recruitment at the same time that you submit the prevailing wage request, because you don't want your recruitment to expire before the Department of Labor issues the prevailing wage request. So you probably don't want to start recruitment until prevailing wage request has been pending, at least 3-4 months. The second issue is that there are some advertisements that require you to list the salary. And if you're in a state like New York, where you have to list the salary in every single advertisement, you take the risk that the salary that you're risking on the salary range you're listing on your advertisements are lower than the salary that the Department of Labor comes back with. And if it's lower than the salary that the Department of Labor comes back with, now you have to restart and rerun that entire recruitment. Again, it might not be the entire recruitment if you're not in a state that requires you to list the salary on every single advertisement. But if you're in a state like New York, you have to do the entire process. So, there's some risks. So why do it? Again, it's because, work visas have a finite expiration date. So sometimes you're trying to expedite the process, and even a couple of months can make a big difference. And then, if you're a large or mid-sized employer, or even if you're a smaller employer, but you have multiple employees that require a perm with the same job title, same job requirements, same location, same employing entity, then you have the option to run batch recruitment. And so typically what that means is that at any point in time, you have a valid prevailing wage request that you can use to run recruitment. And you don't run recruitment for just one role. You run recruitment for multiple positions of that same role. So let's say, you have an ongoing PERM application that you're ready to file, and you have an employee that just joined your company in that same role, and you want to sponsor them for a green card, you can. You just add them at the very end, and their PERM process took 2 weeks to complete. So sometimes doing batch recruitment and having recruitment available for multiple positions can be helpful. But there's also some risks involved in that. So if that's something that you want to consider, you should definitely speak with legal counsel about how to go about that process, and also make sure that you're protecting yourself from some of the risks associated with it.
Absolutely. As Belma said, if you do have questions on this process, reach out to us anytime. Info@trug.com will connect you with Belma. So, Belma, I know we are a little over on time, but I want to ask you one more question. What else should managers take into consideration when starting a green card process for their employees?
So I think the famous issue is the EB2 or EB3 dilemma. So employment-based preference, second employment-based preference, and third-based employment preference, that's what EB2 and EB3 stand for. And the idea behind that is that when you're getting ready to file that final step of the green card process, that third step, one of the governing factors is what preference classification your employment-based petition falls under. And typically what we see is that second employment EB2, which is the second employment-based preference classification, those 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 roles have green cards more readily available to them. So it's a faster process if the role falls under EB2 for an employee than if the role falls under the EB3 preference classification for an employee. So lots of time employees will want to have their role classified as EB2 instead of EB3 in hopes of getting their green card sooner. And the preference classification is determined based on the minimum requirements for the role. So if a role requires a master's degree or higher, or if it requires a bachelor's degree and 5 years of progressive experience, then that's considered an EB2 role. If the role requires a bachelor's degree and less than 5 years of experience, then that's an EB3 role. So you'll have employees tend to push their managers to qualify for EB2. And I'm just here to tell you, it's not about what your employee wants. It's about what the minimum requirement for the role is. So if the minimum requirement is a bachelor's in 4, that's going to be an EB3 role. And that's what we need to list when we recruit for the position. It's something else to take into consideration is, again, work visas are not finite. They have expiration dates. You have to make sure that you're starting the green card process early enough so that your employee's work visa does not expire before they receive a green card. And now the next question I get, but you told me it takes, 10 to 12 years for an Indian born national to even be considered for filing the adjustment of status, but their H-1B visa is only valid for 6 years. What do they do? Well, luckily, H-1B visas have a very special provision carved out for them that allows them to qualify for post-6-year extensions, right? So extensions past their 6th-year maximum as long as certain milestones in the green card process are met. That's why it's so important that you start the green card process for H-1B employees early on so that you make sure they meet those specific milestones, and that for individuals who are in L1B status, for example, that you start the process early enough so that they also, not just the green card process early enough, but the process to get them an H-1B, especially if they're an Indian or Chinese born nationals who face backlogs in filing that final step, so that they can qualify for a post-6-year extension and don't have to leave at the end of their 5th year in L1B status. Another consideration is that some of your employees aren't here at an HRL. They might be here on a strict non-immigrant visa, like a TN or an E3. And those visas come with an intent to return to their home country at the completion of their assignment. So you have to be extremely strategic about when you start the green card process for someone on a TN or an E3, because you want to make sure that they've just renewed their visa and that you have enough time for them to go through steps 1 and 2 and 3 without jeopardizing their ability to extend their stay or have them face a gap in work authorization. So there's lots and lots of considerations during the employment-based green card process. And I'm here to walk you through it, and so is any of the other attorneys at our firm. So thank you, Arianna, for your time. I appreciate your patience while I walk through this.
No, thank you so much, Belma. I appreciate the great insight from you and taking the time to be here with us today and break this down for us. So that is all we have time for today. So this brings us to the end of our conversation. Thank you everyone for joining us today. A special thank you to you, Belma, for your time and insights. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, email us anytime at info@chug.com, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you, everyone.